This video addresses recent Supreme Court decisions impacting debt collection practices and offers guidance for individuals dealing with debt collectors, original creditors, or companies that purchase debt. Business owners and investors should also note recent shifts in vendor pricing, including increases in invoicing software, credit card processing fees, and liability insurance rates, all of which affect operational expenses and financial planning. Key Supreme Court decisions affecting debt collection. Midland Funding LLC v. Johnson. This case involved Midland attempting to collect on a debt already included in the debtor's bankruptcy matrix. Bankruptcy law typically bars creditors from pursuing debts covered by a bankruptcy discharge. However, the Supreme Court determined that, because the individual had the opportunity to object to the claim in bankruptcy court, they could not later sue Midland for attempting to collect on this debt under the Fair Debt Collection Practices Act, FDCPA. This decision places limitations on the legal recourse available to consumers when debt collectors attempt to collect on discharged debts. Henson v. Santander Consumer USA. In this case, the Supreme Court ruled that entities that purchase defaulted debt and attempt to collect on it solely for themselves are not considered debt collectors under the FDCPA. This means that companies engaging only in the purchase and collection of their own acquired debt can bypass FDCPA requirements. The decision is significant because it allows debt purchasers, structured as independent entities, to avoid the compliance obligations typically imposed on debt collection agencies. Objuski v. McCarthy and Holthus LLP. Here, the Supreme Court determined that entities engaging solely in non-judicial foreclosure processes are not classified as debt collectors under the FDCPA, with the exception of certain specific provisions. This exemption means that non-judicial foreclosure entities are not subject to the broader communication restrictions typically applied to debt collectors. Rotkisk v. Clem. The court held in this case that the statute of limitations for filing a claim under the FDCPA begins on the date the alleged violation occurs, rather than when the violation is discovered. For consumers, this means that the one-year statute of limitations begins to run on the date of the violation, regardless of when they become aware of it. This ruling underscores the importance of prompt action if debt collectors violate FDCPA provisions. Practical steps for individuals dealing with debt collectors. If faced with a debt collection lawsuit, individuals are advised to seek legal guidance or explore self-help resources to understand their options. Where a default judgment has been entered, there may still be avenues for relief. Additionally, those who have not yet engaged in credit repair should consider obtaining a comprehensive review of their credit report and identifying potential areas for improvement. To ensure accurate information, it is recommended to access credit reports and scores from all three major credit bureaus. Early engagement with debt collectors through appropriate validation requests can also be helpful in addressing collection issues before they escalate, saving time and minimizing potential costs.